Hi, today I wanted to discuss what happens when you are sued with an enforcement petition in Texas family law for either not paying support or not allowing the other parent to see their child. But first, remember, all information on the yourchildsupportlawyer.com blog and on these videos are for educational purposes only and do not constitute legal advice. In Texas, if you are sued with a motion for enforcement of child support and or medical support or even for possession and access, it's a pretty serious issue. You are now the respondent, also known as the defendant in a criminal case. Whether it's for enforcement of support or possession, the party bringing the lawsuit wants to find you in contempt of court for having failed to follow what the judge ordered. Both support and possession enforcement lawsuits sometimes request up to 180 days in jail or some other specific punishment. In a motion to enforce child support, the request for jail may also be accompanied by a request that you be placed on what's called community supervision. Motions for enforcement of possession and access may also request jail time, community supervision, or make-up time for the parent who was allegedly denied their access to the child. Both support and possession denial types of enforcement cases are serious because in Harris County, Texas, for example, failure to show up to court and respond to the allegations made against you may result in orders for your arrest. Unlike other types of lawsuits, enforcement lawsuits involve punishment, which includes the possibility of a sheriff's deputy physically incarcerating you by order of the judge. Now, when I used to work as an assistant attorney general in the 4D child support court, I had the opportunity to argue motions before the judge that resulted in the person failing to pay child support getting locked up. If you are sued with a motion for enforcement, the first best response is to first retain legal counsel who can walk you through the best defenses to the lawsuit, including filing your answer for you. There are serious consequences for someone bringing up false or frivolous lawsuits against you. So it's smart to determine first that all the claims made against you are legitimate and have merit. If the claims made against you are merited, then you may have to plead any affirmative defenses that you might have, such as an inability to pay or voluntary relinquishment of the child. Or if you have no affirmative defenses, it may come down to you bringing your side of the story to the judge and having the judge make a decision on whether or not you are in contempt of court. Now keep in mind, many enforcement lawsuits for non-support or for possession denials do not ultimately get resolved by the court. They may get resolved by the parents themselves through mutual agreement. A mutual agreement to resolve a child support lawsuit may involve the respondent obligor paying some or all of the arrears balance off. A mutual agreement to resolve a possession denial lawsuit may involve the non-custodial parent getting some extra time with the child to make up for the time he was denied the child. But almost all enforcement actions, whether they involve child support enforcement or possession enforcement, will involve a request for some sort of attorney's fees to be paid back to the parent bringing the lawsuit. And why is that? Because they felt they were forced to resort to the courts for justice when they would have not needed to sue the respondent if the respondent had just followed what the court order said. Oftentimes, both agreed enforcement orders and court-ordered enforcement orders contain the requirement that the respondent pay the petitioning party's attorney's fees. If you're sued with a motion for enforcement of any kind, it's important to know that because you have certain due process rights in this country, if the lawsuit requests that you be put in jail, then if you do not have enough money to get a lawyer and the court believes that you are financially indigent, you may qualify for a free attorney to help you protect your rights. But if you are not financially indigent and you can retain legal counsel, it's best to choose someone with experience in prosecuting or defending enforcement lawsuits to protect your rights under the law. That's it for now. If these videos are helpful, please subscribe and follow us. Thanks.